Mr. Burns.
Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and I represent Mr. Howard. Let's talk about strikes. When Congress enacted the Prison Litigation Reform Act, it did not envision a scheme in which dismissals for failure to state a claim expressly without prejudice qualified as strikes. We know this from several circuits, including the 2nd, 4th, and 7th circuits, which have held that in Snyder against Melendez, McLean against the United States, and Paul against Marbury. The only circuit I've identified that has directly addressed this question in holding is the 8th Circuit in Orr against Clements. So as I view it, there's a 3-to-1 split in my favor. But what I'd really like to talk with you about is first principles, and that has to do with statutory construction. The phrase in the Prison Litigation Reform Act that we need to figure out what it means is this phrase, fails to state a claim upon which relief may be granted. Now, the case law and the rules of civil procedure are clear that that phrase means with prejudice. We know that from the case law interpreting Rule 12b-6, and we know that from Rule 41b itself, which says, unless otherwise stated, a dismissal for failure to state a claim is with prejudice because it reaches the merits. And that's what the 4th Circuit did in McLean. It looked at this rule and it says, well, we know this, so this is what the phrase means, and therefore, when the statute says that, it means with prejudice. But it goes further. It says, well, what if this is ambiguous? Then let's look at the legislative history. And the legislative history indicates that we're not looking to eliminate prisoner lawsuits. We're looking to improve the quality of prisoner lawsuits and get rid of the meritless ones. And so a rule that eliminates lawsuits that were dismissed without prejudice for failure to state a claim wouldn't advance that purpose.
Are you saying that it should be that the cases in that category should be treated in the same way as cases that are dismissed for failure to state a claim for failing to follow court orders?
Well, that's interesting.
Thank you.
That's an argument that I said was waived in the response brief. I said they didn't make this argument that it's being dismissed as malicious. But the state in its reply brief said, well, this is why we think it's a strike, because it's malicious. So in my view, that argument was waived in the trial court. It was abandoned in this court, and you're not to consider it. And even if you were to consider it, this is something that you would ordinarily have a district court do in the first instance. You wouldn't just write without hearing the district court's analysis. But in this circumstance, if you were to address it on its merits, I think that would be wrong, because in this case that we're talking about, which is the dismissal in case 994, the prisoner says, oh, I didn't amend my complaint because I didn't get my mail. He says that in his, I think, motion for reconsideration or motion to amend the judgment after all of his lawsuit has been dismissed. And that's something that commonly happens in prisons. The mail systems are, I know this from my experience, the mail systems aren't very good, and so prisoners, I'm sorry.
Is this the only case dismissed of the potential strikes? In this case, is this the only one that is dismissed without prejudice?
No.
Which is the other one that you are trying to have not counted?
Let's see.
Because it was without
no,
prejudice.
I'm sorry, Your Honor. This is the only one that is without prejudice.
So the circuit split that you're talking about is only applicable to this case?
Case 994.
Correct.
And then
What did 944?
Case 994, and that's the one.
I've got 944. Is it
I may have had a typographical
No, I've got
error in my
994,
brief.
but
I
have
apologize.
994?
Yes,
Okay.
I think
it's
the panel
994.
majority goes in
There is an argument about this Orr against Clements case, which is part of the circuit split that pertains to the consolidated case, whether you count that as 2 strikes or 1.
No, I understand that.
But that's a different circuit split.
Right.
Or a different issue, rather.
It's a different issue.
Okay. So
the circuit split is only applicable to this one case, 10994, and it's a split on dismissals for failure to state a claim as opposed to dismissals for failure to follow a court order.
yes, that's how I view it.
Okay.
Correct. Okay, so what I'm asking you to do is to adopt this majority rule that I think has a sound textual basis in the statute and also sound policy reasons that are announced in the legislative history of the statute.
Can I get you to talk about something that I think is a little bit harder for you, unfortunately? As I understand it, the consolidated cases, I mean, you're arguing those should count as one strike.
Correct.
In the trial court, and then the appeal of the consolidated cases is a second strike. You acknowledge both of those.
Yes. The ones that we agree for sure between the parties is that case 1915 is at least one strike. That's the consolidated case. And that the appeal of that dismissal in case 09-15496 in this court is also a strike.
Okay.
So we agree he has at least two strikes. The question is whether he has 2 or 5 strikes or something in between.
Okay. What I want to talk about is I'm calling it the 2004 case that came here. It was dismissed in the district court because he didn't affirmatively plead administrative exhaustion.
So that's appeal number 06-10707.
Couldn't have said it better myself.
Okay.
So it's here. One sentence, dismissed is frivolous by Judge Marcus, and you assume that it's characterizing it as frivolous on the same grounds that the district court did. Is that? Isn't that?
Yes. My reading of that opinion is the case law in the 11th Circuit at that time said you had to plead exhaustion. He didn't do that. It's dismissed. He takes the appeal. This court looks at it and is like, "What's wrong with you? You didn't plead this, and our case law clearly says that. So your appeal is frivolous. We're dismissing it."
Okay, so here's my question. It's a long setup for a question, but this is what I need you to help me with. What if, how do we know what Judge Marcus, why he thought it was frivolous? Maybe he considered it on the merits and said, well, that he foresaw what the Supreme Court was going to say about pleading administrative exhaustion is not, doesn't have to be pled by the inmate. So he went ahead and looked to the merits, and that was what he meant in that one sentence when he dismissed it as frivolous. Do you lose?
I understand the question. I guess my first response is that wasn't raised, but that doesn't really help me.
That's right. No, that's one thing I was worried
I don't
about.
know immediately the answer to that. I would assume that it was based on that initial reaction, because if I were the person who received that file, I'd be like, oh, this is easy. We have this case law, and it's we don't need to do that. So I don't think there was any cause to go beyond that initial pleading problem and address the merits. But whether you could infer something further, I don't know if our case law says that you can or cannot. I don't.
Well, the district court didn't count that anyway.
Correct. The district court didn't count that, but the question is, should this court continue to count it as a strike? Because that's what the prison is asking you to do here. So I'm sorry, I just don't. I don't know.
Well, I think that the answer might not be good for you.
I can see how it would not be good for me, but I don't. I just don't know.
You think that's not in the case?
My reading of that dismissal, the frivolity dismissal, this court's frivolity dismissal, was just you didn't plead exhaustion, therefore it's frivolous. But I guess I suppose if you go further, I don't think the district court, after all this happened and the cases are consolidated and it's dismissed in case 1915, it's not dismissed as frivolous, it's dismissed for failure to state a claim. So I guess that would be quite the inference that we would be making, that Judge Marcus saw that this case was frivolous on the merits, because even the district court didn't find that after it had seen amended complaints and done a lot more work.
It's, in terms of frequent filers, which we see around here, your client really isn't one of those. A lot of these suits are kind of growing out of that same issue.
Right, and this is an interesting issue because the prison cites or against Clements, and it says, oh, this case is on all fours, and when you consolidate a case, it's still 2 cases, and you count that as 2 strikes. I see that case as very factually different. The first dismissal there, in or, was not a strike because it wasn't expressly without prejudice. So that's what we were talking about before, how this or is relevant to the second issue on this case. So I think it's factually distinguishable because of the first issue in the appeal as I briefed it. And then the second dismissal was definitely a strike in or because he reached the merits and he just said, you don't have a claim. But it's the factual difference is in most cases, and in or specifically, the reason the guy filed 2 complaints was the prisoner's fault. Like in or, he didn't, like he said, the district court said, you need to amend by this day. He didn't do that, and then he has to file a second complaint, and then both of them get dismissed. That's the prisoner's fault. He didn't file the amended complaint within the deadline. But here, it's not the prisoner's fault. The district court dismissed that first case based on law that was proven to be wrong in Jones against Bach, and when the Supreme Court says something, that's what the statute always has meant, and so therefore it was wrong at the time, and that's why this whole procedural rigmarole happened. It wasn't the prisoner's fault.
Are you applying retroactivity principles then to decide whether it should now be viewed as frivolous, even though at the time the appeal was filed and decided the law did require the dismissal?
No, I'm not. The prison cites the Strope against Cummings case, and first of all, thank you to the prison because I looked for that kind of case and I just couldn't find it, and that's important for the court to know that everything is here.
Tell me why you think we shouldn't follow it.
Yeah, I see that as different for a number of reasons. One of them is just a simple atmospheric point about the Tenth Circuit. They didn't appoint counsel there. They had the prisoner brief his appeal, and he didn't file a brief. So they were just sort of guessing. But the reason the retroactivity principle is not what I'm arguing is I'm making a textual argument based on what the Prison Litigation Reform Act actually says. The phrase is, was dismissed.
So was the prison.
I like mine better. But the phrase says, was dismissed on the basis that it is frivolous, malicious, or fails to state a claim. So I see there are 2 tenses there, and the fact that there are 2 tenses there controls, and this means that Congress envisioned the problem that we have in this appeal, which means that we should win. The retroactivity principle.
You're giving Congress a lot of credit here.
Of course, as we should. But the retroactivity principle I understand as concerning criminal law, and it's primarily to deal with habeas cases. So we always have this question when the Supreme Court decides some watershed criminal case, what do we do with all these habeas petitions? And so there's this question like, is it retroactive or not? And then how do we decide those habeas petitions?
Sure.
But this I decide, may I continue?
Yeah, go ahead and ask.
And I have a question.
Yes.
Did I finish answering your question?
I think you did.
Okay.
But I wanted to know your answer to this before your opposing counsel got up. So on the consolidated cases, it's my reading of the record that your client didn't ask us to revive the old case. And
he did not ask anybody to. It was the district judge who did that. And that's just that in and of itself is an interesting procedural outcome. Like how did that happen? Why did the district judge do it? What was its authority for doing that? I don't know. It just happened.
Yeah. Okay. And so one of your arguments, I guess, is that it shouldn't be charged to my client because he didn't ask us.
He didn't do it.
Yeah.
Yeah.
Okay. Got it.
Right.
You saved for about time.
Okay. Thank you.
Mr. Neff.
Good morning, ladies. Good morning, sir. Lance Eric Neff from the Office of the Attorney General for the great state of Florida, and may it please the court. The opening line of 1915G states, in no event. The statute then goes on to give the only exception to that in that rule for the 3-strike rule, and that is imminent danger. However, in Florida, at least 3 district judges believe that there's somehow an equitable exception read into that rule. It happened twice in this case at document 70 at page 6 and at document 91 at page 19. And we had one judge in Jacksonville who thought there was an exception there, and we attached that case to the response to our motion to dismiss this appeal. So you can see that there as well. So we know at least 3 judges there think there's an equitable exception. I would ask this court, regardless of what they do in this case today, to be more explicit than the Supreme Court was in Tollefson and say there is no equitable exception in the plain language of this rule, and tell the court, the district courts who think otherwise in the state of Florida, please follow the rule and follow the guidance of the plain language of a co-equal branch of government. From that said, I would like to talk about the 5 strikes that we believe are our strikes, or the 5 cases that we believe are strikes.
May I ask you to focus first on the question of the change in the law and the effect of that on the frivolity finding or frivolousness finding, and they address specifically the language of the statute that deals with the tense changes that opposing counsel referenced. I mean, the question is whether the case was dismissed on the grounds that it is frivolous, but it is frivolous no longer.
Yes, ma'am. And I believe my esteemed colleague here, Mr. Burns, cites to a case from this court that says that once the law is changed, that's what it's always meant. But that was a criminal. First of all, that was a concurring opinion and a dissenting opinion by Judge Martin here. It was not the main opinion of that case, which was Bryant v. Warden. And it was also discussing a criminal statute, not a civil statute. The discussion of retroactivity in a civil statute has been done by the Supreme Court in Harper v. Virginia versus Department of Taxation, which can be found at 509-86 at page 97. And what it says is that when a court applies a rule of federal law to the parties before it, that rule is controlling interpretation of federal law and must be given full retroactive effect, and all cases still open on direct
If I
review.
was the court reporter, I'd tell you to slow down.
Yes, ma'am.
Thank you.
I'm sorry. So that case, which we're talking about here, which was 06-10707, it was not still open. It was not still on direct review when the new rule came out in Jones v. Bach. Thus, it does not change the fact that it's still frivolous. It's still a strike.
Is there an analogy here to a Heck v. Howard kind of situation in which if there's an underlying conviction and the law has changed in a way that might make that underlying conviction improper for some reason, but there has been no action taken by the convicted defendant to have it set aside or expunged, and instead he brings a 1983 claim based on that?
Yes,
Would the
ma'am.
court have jurisdiction to consider that claim until if it still stood as a conviction, even if the law had changed in the interim?
I believe that unless the inmate had come to this court and asked the court to rescind its previous decision that this was frivolous, then it stands. Otherwise, you're reading an equitable exception into the rule that's just not there. He has to follow the rules, and this court has stated even pro se folks have to follow the rules of procedure. They must.
So he
do
could
that.
have brought a 60B argument, maybe?
Something like that, yes, ma'am. And saying, please, if the law's changed, please reconsider your previous dismissal as frivolous.
60B6.
But,
60B6.
yes, sir. Yes, sir. And I'd also like to discuss the point that Judge Martin brought up regarding it was dismissed as frivolous. What do we know what Judge Marcus was doing? When it came back to this court, it was also dismissed as frivolous. The exact same case. So maybe Judge Marcus was actually thinking he wasn't looking just at the exhaustion issue. He looked at the entire file. Said,
But we
no,
don't
this is
know.
frivolous. We simply don't know.
just don't
Yes, ma'am. We simply don't know. I would also like to briefly discuss the consolidated cases. Now, my colleague agrees that one of the consolidated cases does apply as a strike. He disagrees that the 04 CV 312, he doesn't agree that that applies as a strike.
It's kind of a harsh result, isn't it? I mean, he didn't ask us to revive it. I mean, the district court, the court does that on its own, and we're going to charge him a strike for that? I mean,
It was a different case. He asked, I don't know if that's exactly true. I went back and looked at that, and I know that in the order, the judge did say that we're not going to make you file a new case. We're just going to reinstate that case, and we're going to consolidate it with this one. Regardless, I think the textual language of 1915 says each case brought, each appeal brought. They were two different cases. One was an Eighth Amendment claim, one was a First Amendment claim.
What does it mean, brought? I mean, if the judge picks it up and puts it in there on its own accord, the inmate didn't bring it.
He brought it originally, ma'am. Which is
I
why
know,
it was a
but
different.
so you count it twice. I mean, I understand your argument.
And again, ma'am, I understand the thinking that it may be unfair, but there is no equitable exception in this rule.
I'm not. I mean, the statute doesn't require us to count it twice, does it?
I believe it does. I believe Section 1915G requires it because it says each case brought, each appeal brought. It was brought two different times.
A case is consolidated. You read the statute to expressly require us to count both.
Yes, when something's consolidated, they travel under a single roof, but they are still separate cases. And I believe that regardless.
Well, in theory, the court could order them to put them in one complaint.
That's very well.
No, and then it'd be one case.
Yes, sir. And what the inmate could have done, he could have said, instead of
how much time are we going to spend reconstructing all these things? What I'm concerned about.
Well, that is a fair point, Your Honor. And what the inmate could have done is said, go and try to reopen the first case, and then bring everything.
Presumably, when the judge consolidated them, he understood the three strikes problem in the act, and he essentially put them in one complaint.
Well, he still let them travel as separate cases, though.
I understand he did.
He did, Your Honor.
Well, a lot of times we have consolidated appeals, and they're really one case.
Well,
Do
consider
you follow me? We write an opinion in one and it disposes the other one because they're all the same.
Yes, sir, and I understand. But consider this hypothetical. An inmate brings a First Amendment claim on a same set of operative facts, one set of operative facts. Brings a second case on an Eighth Amendment claim under different operative facts, and so on and so forth. Under my colleague's theory here, he could only ever be given one strike because they're under the same operative facts, regardless of how many cases he brings to the court. That would be something that Congress did not allow. If all of those things were frivolous or they were dismissed for failure to state of claim, they should each get a separate strike.
That's obvious.
Okay, so humor me for a moment.
Yes,
and
ma'am.
I'm not ruling, and I'm not telegraphing anything, but do the arithmetic for me.
Mm-hmm.
Let's assume we conclude, for the purpose of just this arithmetic exercise, that this should only be counted as one strike, the consolidated cases, not two. What's the effect given the number of given the appeals on the calculation? You argue for a total of 6 strikes, I believe.
Five
strikes.
Yes, ma'am.
And if you discount or uncount one of the strikes that are included in the consolidated cases, what do you get when you carry that ripple effect through? How many fewer are you left with?
That would still only take away one, because I believe there's the original appeal, which is not changed by retroactivity.
But there's also the appeal,
There's the
right?
latter appeal, which counts as a strike. Yes, ma'am. So there's two. There's no one that's disputing that there's 2 strikes here.
Okay.
The question is whether any of the other 3 cases are a strike.
Well, I understand that. So my question on the effect of not counting double, if you will, for the consolidated cases is what? How many strikes do you lose from your total of 5?
I believe you'd only lose 1, Your
Okay.
Honor. You'd only lose
All right.
one.
I just wanted to make sure that I was understanding
Yes,
it
ma'am.
properly.
And then briefly, I will talk about the dismissal without prejudice in 10994. I believe this court has already determined in Rivera v. Allen that such a dismissal without prejudice would be a strike. And you can look at page 731 of that opinion, where this court specifically said that a dismissal without prejudice could count as a strike. I know that my colleague here cites an opinion that says that if a judgment is not entered in a case, then it's still open. Well, he cited a case from 2001, and that was prior to the 2002 amendments to the Federal Rules of Civil Procedure, which included in 58C2B an amendment which took care of that situation. When something's dismissed and there's no later judgment entered, Now, as since 2002, 150 days after that, it becomes a final judgment regardless of what the court does. So that case should also count as a strike in our opinion, regardless of whether judgment was ever entered in that case.
Even if it was dismissed for failure to follow a court order?
Yes, and that would be an abuse of the judicial process, which I believe in Rivera this court has stated would be a strike, even if it's without prejudice. Yes, ma'am. Yes, ma'am. In my final 4 minutes, I want to briefly state also why the officers should have been granted qualified immunity. Now, in this case, on the merits, an inmate argued that he had moderate chest pain after he had been ordered to clean the showers. He did not make any other assertions, not that his left arm was hurting, not that he was sweating, not that he was, not that his was short of breath or anything else. He had a 16-page complaint and a 57-page appendix to his complaint. And when in those documents, he never states anything else other than very moderate chest pain. He doesn't state that this very moderate chest pain resulted in any injury whatsoever. And perhaps most damning to his case is that in the attached notice of claim, he stated he filed with the state so that he could pursue a tort claim, which is in the appendix to the complaint at document 1-1 at 4647. He says absolutely nothing about injury. Also in the attachments to the complaint, in the numerous grievances that he attaches to them, he says nothing about injury, nothing whatsoever. Now, prison guards in the state of Florida are outnumbered by prisoners 20-1. These prison guards spend 12 hours a day with these prisoners. Many of these prison guards spend more time with these prisoners than they spend with their own families. That being said, they know the prisoners. When someone makes an allegation of injury, without any outward manifestation whatsoever of any sort of actual ailment, the guards who know these prisoners should have the discretion to say, not right now, not right now. Not unless they're falling on the ground, not unless they're holding their arm, not unless there's something more than just saying, I have chest pain, moderate chest pain. Because if you allow an inmate to state a claim by merely stating moderate chest pain without any observable identification of anything else, the inmates will be running the prison. Because all they'll have to say state a constitutional claim is, oh, I have moderate chest pain, not be showing any other signs of anything else. And then we have to be taken to immediately, the guards will have to stop what they're doing, being taken immediately to the medical folks. Otherwise, they get a constitutional claim against them. That simply cannot be the law, because that would allow the inmates to run the institutions. Just can't be done. Thank you very much for your time. Unless you have any other questions, that's all I have.
Mr. Burns.
Just a few points. This question about the equitable exception, I briefed that extensively. That's just not the issue here. It's a question of statutory interpretation. What does the PLRA mean? And although the district court used unfortunate language, you read district court language charitably. This is just a textual interpretation question.
Well, I'm all in favor of reading district court judges' language charitably, but when the judge says, I think essentially says, I'm not basing this on the language of the statute. I'm basing it on what I think is a fair result.
I don't think that's a fair...
That's not a little troubling?
I don't think that's a fair reading of what the district court said. I think the district court said, it doesn't seem fair to me to read this as a strike. Now, that doesn't mean I'm not reading the statute, because that would be a shocking thing for a district court to do, to say, well, the law says this, but I'm just not going to do it. I don't think what the district court was saying. The district court was saying, as a policy matter, I don't think this falls within the statute. That's what she meant to say, and that's how I think you should read it. There's this question about the appeal, this 06 appeal, that was dismissed as frivolous, and then there was Jones against Bach, and now what do we do with that? And we just mentioned Coleman Bay against Tollefson. Now, that's actually an opinion that's favorable to me, because there the Supreme Court said, well, if you have 3 strikes and then you appeal the 3rd strike, that counts as a strike until the appellate court reverses it. So you can have something that is a strike and then isn't a strike. So that's not a surprising result. And here, like I said...
on direct appeal. We were not on direct appeal anymore.
Right. But what I'm, like I said before, making a textual argument about the tenses. And because of the tenses, I'm not talking about retroactivity. I'm just talking about how you read the statute and after the fact decide what's a strike and what's not. We mentioned whether the consolidated cases are 2 cases or 1. The second case actually attaches the complaint from the first case, and so for that reason, it incorporates all of its allegations, and they are the same case because they have the same allegations. The 994 case and the judgment issue, opposing counsel is correct, there is the 2002 amendment, but that doesn't address the without prejudice language of the order, and so we don't know until we resolve the circuit split whether that counts as a strike or not. And then finally, as to qualified immunity, it's just premature to resolve on this record whether there was qualified immunity until the prisoner has had a chance to amend his complaint. Certainly he didn't state a claim here, but if he had the opportunity to amend, he might be able to, and as I indicated in my reply brief, I don't think there would be qualified immunity from that kind of amended complaint. Unless you have further
I think
questions.
your time's up.
Okay, thank you.
You were court appointed, and we appreciate your
All
having
right,
taken
thank you for the opportunity.
Thank you.